Namaste, I'm Atuldat from LawQuest. In this video, I will be explaining the legislative relations between the center and the states in our country. India is a federal country, therefore powers are distributed between the center and the states. Article 245 to Article 255 under Chapter 1 of Part 11 of the Constitution describes the legislative relation vested in the center and the states. The first article is Article 245, deals with the extent of applicability of laws made by the Parliament and the state legislature. Parliament may make laws for the whole India, while the state may make laws for the state concerned. And Parliament may make laws having extraterritorial jurisdiction, that is, laws operative outside the territory of India. But a state legislature can't make laws having extraterritorial jurisdiction unless there is a sufficient connection between the state and the subject matter of law. Article 246 deals with the subject matter of law making of the Parliament and state legislatures. Parliament has exclusive power to make laws with respect to matters enumerated in the Union List. State legislatures have exclusive power to make laws with respect to matters enumerated in the state list. Both Parliament and the state legislature have power to make laws with respect to matters enumerated in concurrent list. Parliament has powers to make laws with respect to any matter in any list for the union territories. Now, the third article is Article 247, deals with the power of the Parliament to establish certain additional court. Parliament has the power to establish additional courts for better administration of laws made by the Parliament or any existing laws with respect to a matter in the Union List. Article 248 deals with the residuary powers of the Parliament. Parliament has power to make laws with respect to matters not enumerated in the concurrent or state list. The fifth article is Article 249, deals with the power of the Parliament to legislate on a matter in the state list in national interest. Parliament can make laws on a matter of the state list for any state or states if Rajya Sabha passes a resolution to that effect, in opinion that it is expedient in national interest. The sixth article is Article 250. The Article 250 deals with the power of the Parliament to legislate with respect to matters in the state list while a proclamation of emergency is in operation. In event of a proclamation of emergency, the Parliament has the power to make laws on matters in the state list. The seventh article is Article 251. Article 251 deals with the inconsistency between the laws made by the Parliament under Article 249 and 250 and laws made by the state legislature. When inconsistency arises between a law of the Parliament made under the aforementioned articles and a law of the state legislature, the former will prevail, and the state law shall become void to the extent of inconsistency. The eighth article is Article 252, which deals with the power of the Parliament to legislate for two or more states. If two or more states find it desirable that the Parliament should make laws for them on a matter in the state list, and they pass a resolution to that effect in their legislature, the Parliament can legislate for such states on the matter specified in the resolution. The ninth article is Article 253, which deals with the legislative power of the Parliament to give effect to international agreements. Parliament can legislate irrespective of the list to implement a treaty or a decision made at international convention. The 10th article is Article 254, which deals with the inconsistency between the laws made by the Parliament and laws made by the state legislature. In case of an inconsistency between a law of the Parliament and a law of the state legislature on a matter which the Parliament is competent to enact, that is, matter in the Union list, the former prevails. If inconsistency arises between a law of the state legislature and a previous law of the Parliament on a matter in the concurrent list, the state law will prevail if it has received the assent of the President. However, Parliament can afterwards make a provision inconsistent with the previous laws of the state legislature. The 10th article is Article 255, which is also the last article for this topic, deals with the requirements as to the recommendation and previous sanctions. No act of the Parliament or state legislature will become invalid by the reason only that the recommendations or previous sanction of the President required by the Constitution as under Article 117, 207, 304 was not given if the assent is given to it by the President subsequently. Hope this video helps you in understanding the legislative relations.